And the reason why that argument is in such bad faith, as I pointed out to you yesterday, that while they're in this body arguing the House was derelict, slapdash, they should have fought harder and longer and endlessly to overcome our stonewalling, while they're making that argument to you, the House should have fought up and down the courts, from the district to the Court of Appeals, the Supreme Court, and back again. They're in the courthouse arguing the opposite. They're in the courthouse saying, Judge, they're trying to enforce a subpoena on Don McGahn. You need to throw it out. They don't have the jurisdiction. This is non-justiciable. You can't hear this case. That is a really hard argument to make. I credit them for making it with a straight face. But that's the character of it. You should have fought harder to overcome our stonewalling and obstruction. Now, they also say the Chief Justice cannot decide issues of privilege. No, the Chief Justice can't make those decisions. You need to let us litigate this up and down the court system. That's a pretty remarkable argument, because the Senate rules allow the presiding officer to make judgments, to rule on issues of evidence, materiality, and privilege. That is permitted under your own rules. We don't need to go up and down the courts. We've got a perfectly good judge right here. Now, you heard our proposal yesterday that we take a week, just a week, to depose the witnesses that we feel are relevant, that they feel are relevant, and that the justice rules are relevant. Just 1 week. Now, they can say that the Constitution requires them to go to court, but of course it doesn't. There is absolutely no constitutional impediment from these fine lawyers saying, you know, that's eminently reasonable. We will allow a neutral party, the Chief Justice of the United States of America, to rule on whether a witness is material or immaterial, whether they're being called for purposes of probative evidence or harassment, and whether you're making a proper claim of privilege or merely trying to hide crime or fraud. The concern they have is not that this Chief Justice will be unfair, but rather that he will be fair. But do not make any mistake about it. Do not let them suggest that there is something constitutionally impermissible, or it would violate the President's rights to allow the Chief Justice of the United States to make those decisions in this court, because he is empowered to do so by your rules and by the Constitution, which gives you the sole power to try impeachments. In the sole exercise of your power to try impeachments, you can say, we will allow the Chief Justice to make those decisions. Now, Mr. Sekulow said that you've heard the testimony of 13 witnesses. And I think the impression is meant to be given, if not to you, who know otherwise, then maybe to the people watching at home, that they must have been in between errands while watching the Senate trial and missed where those 13 witnesses came before the Senate and testified. But of course, you heard no live testimony in this body. There wasn't any live testimony before this body, and I don't recall any of you in that super secret basement bunker they've been talking about. Now, I'll admit there were 100 members eligible to be there, so maybe I missed one of you. But I don't think you were there for the live testimony in the House. Now, Mr. Sekulow says the President was deprived of his right of calling these witnesses himself and cross-examining these witnesses in the House, but that's not true either, because the President was eligible to call witnesses in his defense in the Judiciary Committee and chose not to do so. If the President's counsel felt that, you know, Bill Taylor says that he spoke with Sondland right after this phone call with the president, and Sondland talked about how the military aid was conditioned on these investigations. The president wanted Zelensky in a public box. And I'd really like to cross-examine that West Point grad Vietnam vet, because I don't believe him. You know, they could have called Bill Taylor in the Judiciary Committee and cross-examined him. Or they could have called Mick Mulvaney and put him under oath and let him contradict what we now John Bolton would say. But of course they didn't do that. No, they said merely, just get it over with in the House. For all there was too quick, too slapdash, get it over with in the House. Because as the president said, when it comes to the Senate, we'll have a real trial where he gets to call witnesses. But they've changed their tune. Because now they know what they really have known all along, which is those witnesses would deeply incriminate this president. And so, instead, they have fallen back on the argument that if we're going to go down the road to having a real trial, if we're going to go down the road into having a real trial, we, the president's lawyers, are going to make you pay. And the form of this argument is we are going to call every witness under the sun. We're going to call every witness that testified before the House. We're going to call every witness that we can think of that would help smear the Bidens. We are going to keep you here until kingdom come. That's essentially the argument that they're making when Mr. Sekulow says we're going to bring in Fiona Hill and we're going to bring in Tim Morrison, we're going to bring in this witness and bring in that witness. You have the sole power to try this case. You do not have to allow the president's lawyers to abuse your time or this process. You have the power to decide, no, we gave each side 24 hours to make their arguments. We're going to give each side a shared week to call their witnesses. You have that power. If you didn't, you couldn't have constricted the amount of time for our argument. You can likewise determine how much time should be taken with witness testimony. Now, Mr. Sekulow ended his argument against witnesses with where Mr. Philbin essentially began. It all comes back to the Dershowitz principle. What's the point of witnesses if the president can do whatever he wants under Article 2? What's the point of calling witnesses? What's the point of having a trial if the president can do whatever he wants under Article 2? The only constraining principle, and I think that one of the senators asked yesterday, what's the limiting principle in the Dershowitz argument? If a president can corruptly seek foreign interference in his election because he believes that his election is in the national interest, then you cannot impeach him for it, no matter how damaging it may be to our national security. What is the limiting principle? And I suppose the limiting principle is only this. It only requires the president to believe that his re-election is in the national interest. Well, it would require an extraordinary level of self-reflection and insight for a president of the United States to conclude that his own re-election was not in the national interest. Not unprecedented, mind you. I think that was the decision that LBJ ultimately arrived at. But I would not want to consider that a meaningful limitation on presidential power, and neither should you. Finally, the counsel expressed some indignance that we should suggest that it's not just the Senate, it's not just the president, rather, who is on trial here, but it is also the Senate. How dare the House manager suggest that Your decisions should reflect on this body. That's just such a calumny. Well, let me read you a statement made by one of your former colleagues. This is what former U.S. Senator John Warner, a Republican of Virginia, had to say. As conscientious citizens from all walks of life are trying their best to understand the complex impeachment issues now being deliberated in the U.S. Senate, the rules of evidence are central to the matter. Should the Senate allow additional sworn testimony from fact witnesses with firsthand knowledge and include relevant documents, he asks. As a lifelong Republican and a retired member of the U.S. Senate, who once served as a juror in a presidential impeachment trial, I am mindful of the difficult responsibilities those currently serving now shoulder. I believe, as I'm sure you do, that not only is the president on trial, but in many ways, so is the Senate itself. As such, I am strongly supportive of the efforts of my former Republican Senate colleagues who are considering that the Senate accept the introduction of additional evidence that they deem relevant. Not long ago, senators of both major parties always worked to accommodate fellow colleagues with differing points of view to arrive at outcomes that would best serve the nation's interests. If witnesses are suppressed in this trial, and a majority of Americans are left believing the trial was a sham, I can only imagine the lasting damage done to the Senate and to our fragile national consensus. The Senate embraces its legacy and delivers for the American people by avoiding the risk. Throughout the long life of our nation, federal and state judicial systems have largely supported the judicial norms of evidence, witnesses, and relevant documents. I respectfully urge the Senate to be guided by the rules of evidence and follow our nation's judicial norms, precedents, and institutions to uphold the Constitution and the rule of law by welcoming relevant witnesses and documents as part of this impeachment trial. That is your colleague, former Senator John Warner. Senators, there is a storm blowing through this Capitol. Its winds are strong, and they move us in uncertain and dangerous directions. Jefferson once said, "I consider trial by jury as the only anchor yet imagined by man by which a government can be held to the principles of its Constitution." The only anchor ever imagined, yet imagined by man, by which a government can be held to the principles of its Constitution. I would submit to you, remove that anchor, and we are adrift. But if we hold true, if we have faith that the ship of state can survive the truth, this storm shall pass. I yield back.
Thank you, Mr. Manager.
Mr. Chief Justice,
The majority leader
I
is
suggest
recognized.
the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
This is Laura Ingle in New York, and you are watching the senators. We've just heard closing arguments ahead of the crucial vote on witnesses. As we're taking a look at the Senate floor right now, you're hearing silence because there is a roll call happening right now. We do expect the gateway vote to call witnesses to unfold sometime this evening. We're getting this information from our producer and reporter Chad Pergram. He says potentially after a dinner break. So the timing right now is extremely fluid. We're looking at likely a 6:30 to 8:30 p.m. window. That is Eastern time. And he says, we know the outcome of this vote. Senators will expose extending the trial by calling witnesses. There are at least 51 votes to oppose calling witnesses, with Senators Mitt Romney and Susan Collins, both Republicans, voting nay. Then we hear that things could get complicated because the framework resolution, agreed to last week for how the Senate would conduct the trial. Now, this only allows for the Senate to begin to consider other motions. That's where Senate Minority Leader Chuck Schumer, Democrat of New York, could make a series of proposals, all debatable for 2 hours, and then dispense with via a note, practically, going into the night. So we've got a lot ahead of us still here as we are waiting for this next moment to happen on the Senate floor. What's at stake in the negotiation, Chad Pergram writes, is how much time the impeachment managers and the defense counsel will have to present their closing arguments, and how much time senators will have to debate the articles of impeachment on the floor and/or in closed sessions, and if the Senate will consider any other motions or proposals. So when the Senate will take the final votes, rendering verdicts on both articles of impeachment is still something that is unclear, but we are still waiting to find out what will happen here next. You can see there is some action on the floor. We've got some senators talking there to the right. We are trying to get a handle on if this is a break, if this is some kind of a roll call, or where we are going next. Keep it here with Fox News as we continue to work through what's happening on the Senate floor. Watching special coverage of the Senate impeachment trial of President Trump. The Senate is deciding whether to consider witnesses ahead of a crucial vote later today. Fox is being told there are negotiations to try to finish the trial next week. This is a very fluid day in the Senate. Lawmakers right now seem to be taking a break. We will return you to local programming. For some viewers, we will see you when the trial resumes. I'm Laura Ingle. Thanks for being with us.
This has been a Fox News special presentation.